I want to start this video out by saying all constitutional rights invoked, none waived. All constitutional rights invoked, none waived. We're going to get right into it really quickly and efficiently. The defendant, the last defendant that we were waiting on, their motion was denied. Their motion was denied 2 days ago by the federal judge. So the case will be moving on to the discovery stage. Now I want to cover something briefly. I want to talk about two types of evidence. The first type of evidence is circumstantial evidence, and the second type of evidence is direct evidence. The first type of evidence, circumstantial evidence, is evidence that can cause an inference to be drawn. For example, if I go outside and I look at my barbecue grill and I see that smoke is coming from it and it has hot coals in there, I can infer that someone barbecued. I don't know who barbecued. I don't know exactly who barbecued, but I can infer that someone barbecued because they would have had to cause that smoke and heat to happen. So that's circumstantial evidence. The second type of evidence is direct evidence. Direct evidence is going to be evidence that you personally seen. So if I for example, if I'm in Louisiana and I'm on Canal Street in New Orleans, Louisiana, and I see Ronald McDonald, for example, and he goes into a Chase bank. He goes into the Chase Bank, and I go in there to see, whoa, what is Ronald McDonald doing in the Chase Bank? And then when I go in there and I look, I see that he actually robbed the place. He's in there with a gun and he's robbing it. So that's direct evidence because I seen it. So if they pull me into court and they question me and they say, did you see it? Then yes. And they say, and I say, yes, I seen it. If they're recording me, then that can be used as direct evidence. If I give an affidavit attesting under penalties of perjury that I seen Ronald McDonald do that, then that's direct evidence, okay? Direct evidence is something that you've seen or witnessed yourself, or something that happened to you that you could say, it happened to me. I seen it. I was there. I seen it with my own two eyes. And that's what direct evidence is. So, yeah, so those are two types of evidence. Now, I want to talk about that because in our case, a lot of the attorneys, they kept saying, well, they don't have any evidence. They don't have any evidence. They don't have any evidence. We have a mountain of evidence. We have a lot of evidence. We have a lot of circumstantial evidence, and we also have a lot of direct evidence, okay? We have a lot of circumstantial evidence that through the discovery stage can be turned into direct evidence, okay? So we have that. Now, I want to say that that's really important because they are trying to get a premature summary judgment. They trying to hurry up. Oh, we didn't have discovery. Oh, they didn't have discovery. Issue a summary judgment against them. No, not so fast. Not so fast. Because in a lawsuit process, you have something called discovery. So if you get past a motion to dismiss, or you get past a motion for judgment on the pleadings, it moves to the next stage. Okay? That next stage that it moved to is the discovery stage. The discovery stage is the opportunity for you to extract anything that's going to support your averments in the complaint. All right. And it's going to be all the mechanisms that you can use to get the information that you need to prevent a motion for summary judgment being entered against you. All right. And a lot of times when a motion for summary judgment is issued, there has to be no facts that are in dispute. Okay? All of the facts in our complaint, most of the facts are still in controversy. They are still in controversy. They are still in dispute. Okay? These defendants' attorneys, they have not properly disputed our facts. Our facts cannot be disproven. And this is why they want to hurry up and try to avoid discovery. They want to try to hurry up and avoid discovery because they know that those facts in that complaint is going to be supported through certain documents that we make them turn over to us, okay? Through admissions and all kind of different mechanisms. It's no secret, okay? So these people, they pulled the same type of, these same attorneys from Cleveland, pulled the same stuff in Michael Holbrook's court on the state level. In Michael Holbrook's court on the state level at the Franklin County Court of Common Pleas in Columbus, Ohio, in Michael J Holbrook's court, they stayed discovery, okay? And they stayed discovery, and they kept discovery stayed. Discovery was stayed indefinitely, which did not afford us an opportunity to extract any kind of information. They did what they wanted to do down there, okay? And that's why we said that it was totally unfair. It was totally unfair. We didn't have a chance in that state court. We didn't have a chance. Because A, they didn't know who they was dealing with at the time. They didn't know enough about us at the time. They didn't know how hard we work at the time. Okay, so they like, oh, them, just do whatever, throw it out. And I can remember one of the attorneys said in a pleading, actually it was the attorney whose motion just got denied a couple days ago. He said in his pleading, it's time. Throw it out, just throw it out, it's time. You know, so I believe that there was a lot of behind the scenes pressure that was on that state judge, and he just tossed it out. He just tossed it out because the lawsuit was against people he have to deal with every day, and that he has to see every day. So it was almost kind of like a conflict of interest, yeah, I want to say that that's important because now the same attorneys from Cleveland, Jason Winter and Courtney J. Tramaco, is trying to do the same thing. Okay, they're trying to race to judgment without allowing us an afforded opportunity to be able to conduct discovery, knowing good and damn well that Judge Jolson stayed discovery on, I think, 2 or 3 different occasions for, I think it was 60 days at a time each occasion. Okay? All right? So we haven't had nowhere near enough time to perform an adequate and thorough, efficient discovery process. All right? Okay? So I feel like that's important, and that may be one of the tactics they use against people that wouldn't know any better. And you can't use the same trick twice. You can't use the same trick twice. That's going to be the key thing here. And then you're also showing what you did on the state level. You're trying to do the same kind of, unconstitutional things. When you hear all constitutional rights invoked now waived, that's all of them. That's primarily pointing to the main important ones like due process. Okay, under due process you have 2 types of due process. You have procedural due process and you have substantive due process. And under procedural due process, you have to be afford an adequate due process, so there has to be an adequate and fair procedure for you to do what you need to do to be able to find balance in the situation. All right, there has to be due process and there has to be equal protection under the law, which means that this person is given the same equal rights under the law as this person, not no bias and prejudice stuff going on. You see what I mean? So that is very important, and I wanted to touch on that. But I think it's very important to understand the distinction between a person being a plaintiff, a witness and a victim. And I think that these attorneys, they don't realize that we are the plaintiffs, okay? We are the victims, and we are the witnesses, okay? Because a lot of things that was done directly to us, and a lot of it has caused a lot of circumstantial evidence, okay? And a lot of it has caused direct evidence. And a lot of what we averred in the complaint that we have filed, it cannot be disproven, all right? It cannot be disproven. It cannot be disproven. It cannot be disproven, all right? They know this. They know it. You know, for example, we have a divorce complaint that contained complete lies, all right? Complete lies, which was actually a component of a scheme, okay? It was a component of an organized crime scheme, a Hobbs Act extortion scheme, all right? So that is direct evidence that there was a false complaint that was filed, because the false complaint was later withdrawn after being on file and after causing damages for years, okay? For years. Okay? So they allowed that to stand, and they had no credible witnesses to attest to nothing that was contained in that divorce complaint. All right? They had no credible witnesses. They didn't have a shred of evidence. Okay? They didn't have a shred of evidence. They did what they wanted to do. And we gonna get that fixed. Okay? It's being fixed now. So, you know, it's kind of hypocritical, the situation. It's kind of hypocritical because they're saying, oh, in this situation, we don't have any evidence. But Courtney J. Tremaco, which is the attorney for Stacey Gilbert Osborne in the law offices of William L. Geary, LPA, and William L. Geary, they didn't have a shred of evidence in the divorce court going in there with all them lies. Okay? And I do believe that that is a violation of the Ohio rules of professional conduct for that all attorneys is bound to the authorities of. That's a violation. And because a lot of that stuff they knew wasn't true. And that's why there was a lot of manipulation going on with them having Cho-Chun Lu sneak around. She was sneaking and manipulating. And that's why her motion got denied the other day. Okay? Her motion got denied. So we are going into the discovery stage. And we're going to get, we already have some good things, but we're going to get some even greater things to prove that what these people are doing down there is sick. They sick. These are some sick puppies. Okay? And we're going to put them sick puppies in the pound. Okay? All right? So, again, there has been a lot going on. I just wanted to give you guys an update. That last motion that we were waiting on was denied, and to grandmother's house we go, on to the discovery stage. Okay? On to the discovery stage. And again, I want to stress the fact that in our complaint that we filed in this federal court in Columbus, Ohio, a lot of what is averred in that complaint cannot be disputed. Okay? It's from what I have seen, their attorneys have not disputed any of our facts. Our facts are not disputed. It's not. Okay? And many of those facts cannot be disputed. All right? Those facts cannot be disputed because it's all true. Okay? They might not like it, but we don't give a damn. We don't give a damn. We don't give a damn. So we're going to do what need to be done. You know, we're going to have our claims adjudicated. We're going to go through this discovery process, and we're going to rock, and we're going to roll. Okay? That's what we're going to do. And we're going to have an adequate process. We're going to have an adequate and fair process. We're going to present what we need to present and extract from them to prove our case at trial, and it's going to go from there. Okay? It's not rocket science. It's not rocket science. Okay? So again, a lot of our facts in our complaint have not been disputed by these opposing counsel. They've been throwing in motions to dismiss and motions to dismiss and motions for judgment on the pleadings, trying to just hurry up and get through it. You're not hurrying up and getting through nothing. Okay, we're going to get through this. We're going to do this. We're going to take this. This is going to go step by step. Okay, and that is why we invoke many of our constitutional rights. When we say all constitutional rights invoked, now waived, we mean that. We mean that. We mean that. We mean that. All constitutional rights invoked, none waived. It's not no game over here. We standing on our rights. Okay, so you can't play with due process like you did in the state court. We were very, very badly abused in that court. All right? So again, we're going to have a fair and efficient discovery process. There are no more pending motions right now. On to the discovery stage we go, and then they'll be putting in their motions for summary judgment, all the rest of the attorneys, and then we will have everything we need to show that you're not getting it. You're not getting it. Okay, the motion for summary judgment that Courtney J. Tramaco put on the docket right now, that thing is premature. You can't do that. You can't do that. We have to be afforded an adequate opportunity to conduct discovery. And then she turned around and tried to trick the court and say, well, they didn't have any intention on doing discovery, and they didn't provide the exact mechanisms of discovery that they were intended to use. You totally lied. Totally lied. And I sent the emails right into the court for them to put it on the docket. They totally lied. You totally lied. So you just went against the rules of the Ohio, I think it's called the Ohio Professional Code of Conduct, Rules of Conduct or something to that effect. That is mandated by the Ohio Supreme Court. That's why I said these people might need to get a new attorney, because this is sad. But again, we're going to rock and roll, and we're going to see this thing through. Okay? If you guys have any comments, any concerns, any questions that you would like to ask, you can enter them in the comment section, and I will be delighted to address those comments. Also, we would like to urge you to check out InvokeMyRights.com. Check out InvokeMyRights.com. It is our website that teaches a lot of DIY, do-it-yourself mechanisms that you can use if you're ever in a situation where you have to end up in a court, or if you're ever in a bankruptcy situation, or etc., etc. Okay? Now I'm going to conclude this video, and again, all constitutional rights invoked, none waived, and we out.